Number 99. Would you like any rebuttal time?
5 minutes, please.
5 minutes. Okay, go ahead.
My name is Judith Sternberg. I'm of counsel to the District Attorney of Nassau County.
Could you pull your microphone down? Thank you.
Can you hear me better?
Yes.
Yep,
Yes.
better.
Thank you.
This court has long held that a defendant will be responsible for a victim's injuries if the defendant has set in motion a chain of events that foreseeably led to those injuries. Nonetheless, in this case, the appellate division held that the defendant's sober decision to drink to a state of dangerous intoxication with the knowledge and intention that he would later be driving.
Where is that shown in the record that we know that to be the case?
We know that circumstantially. We know that.
How do we know that circumstantially?
It is a reasonable inference that the court drew from the simple circumstance that the defendant drank at a friend's house, the circumstance that a person normally will go home, reasonably can be.
Isn't that a little bit of a leap? I mean, in this kind of a situation where there are such tremendous implications from that inference?
There are. And if the question is whether the evidence was legally sufficient to establish that finding of fact by the court, it's not reserved for review here.
Where do you draw the line? I was trying to think if the defendant was at a wedding and he's happy and everything's thrilled, and he just, drinks too much and ends up doing something like this, is that not depraved indifference because he was happy? But if he's morose and drinks and says, I'm going to drink myself into a stupor and then I'm going to drive the wrong way down the throughway.
No, we have no reason to believe that the defendant here was morose. In fact, he told the police when he was arrested that he had been celebrating.
So isn't it the issue of foreseeability as to whether it's foreseeable that his drinking and his conduct could lead to an accident?
Exactly. And it is the people's argument, and it was the people's argument at trial. And I'd like to point... But
even assuming you're right about everything you've said so far, that it's foreseeable, that he knew he was going to be driving, is it really depraved in the way that throwing a bomb into a crowd is depraved? I mean, is this person really a psychopath, or is he just a drunk driver?
I wouldn't allege that he was a psychopath.
But isn't the depraved indifference murder statute really intended for the psychopath, for the person who literally doesn't care whether other people live or die?
Well, Judge, a lot of people don't care, and they're not psychopaths, and sometimes they don't care because they're
well,
so
did they get
angry.
Did they get convicted of depraved indifference murder?
Well, they could. For instance, if a man, this defendant drank at his friend's house, and he drank to the point of dangerous intoxication. A person knows when they're descending into drunkenness and still chooses to take one more drink and one more drink.
Do they really?
From a public policy point of view, this might be a good rule. I think Judge Dillon called it a plague of drunk drivers on our highways. The Mothers Against Drunk Driving would be very happy if we upheld the conviction here. But from a legal standpoint, especially since Feingold, how can we do that? How can we say that? We adopted a subjective standard. He obviously did not have the subjective mens rea at the time that he got behind the wheel because he was oblivious.
Because he made himself oblivious.
Well, but did he have, even at the time he made himself oblivious, could a fact finder really find beyond a reasonable doubt that at that time he knew that there was a high likelihood that people would get killed and that he didn't care? Isn't the fact that usually when people get drunk, they're idiots, they're reckless, they're irresponsible? I would agree with you they should go to jail, but they aren't consciously thinking, I don't care whether I kill innocent people or not.
They're not thinking, I don't care if I kill innocent people, but they are thinking, I don't care. In general, I don't care the consequences of my drinking. I feel like taking one more.
Why isn't that just reckless?
Because the consequences of that not caring are so depravedly indifferent to human life, especially a situation where...
Consequences are indifferent? I thought we decided in
Oh,
Feingold
I'm
that...
sorry, I misspoke.
I'm not trying to pick on you, but we decided in
I know.
Feingold that depravity is a state of mind.
Absolutely.
So, so the fact that the consequences, if he did not in fact foresee them, regardless of how big an idiot he was for not foreseeing them, if he did not in fact foresee a very, very high risk of death to other people, then how can you say he was depravedly indifferent?
Your Honor, I think...
I mean, he thought he was going to get home safely, didn't he?
I don't know what he was thinking at the time he was driving.
Could a
and
jury
according to
find
the
beyond a
judge-
reasonable doubt that he didn't expect to get home without an accident?
I'm sorry?
Could a jury find beyond a reasonable doubt that he had no expectation of getting home without an accident?
A jury could find, and the trier of fact in this case found, that at the time he drank and chose to take that one more
Yeah, but
drink,
you just
he didn't
admitted,
care.
counsel, you just admitted that you didn't know his state of mind. Your answer to the question before was, I don't know what his state of mind was. How could in this situation, you mean every person who drinks in a bar and then goes home in the car is guilty? They may be guilty of some, if their alcohol level is a certain point of a DWI, but every one of those people
No.
is not. So why this one when you acknowledge that what you're saying is really very inferential, that you're saying that the person drunk a lot clearly had become loopy, didn't know what he was doing. All of those situations, what distinguishes this from all of those situations, especially when there's no real record here of what he was thinking or not thinking?
The people don't suggest for a moment that drinking is illegal, that drinking with the intent to drive is illegal, that driving after you have
So
drunk
what
is
sets
illegal.
this apart?
What sets this apart is the knowledge that you're going to you're going to drive, and continuing to drink when a person, common human experience tells
But
us,
I just asked you,
knows-
what about in every bar in this state, that there are so many people who have too much to drink, one drink and another and too many, and goes out? Is each of those situations, anything to distinguish that? What's unique about this situation?
This is not unique from those situations, Judge.
So then-
If a person does what this defendant did in a bar, knowing he's going to drink, this is to drive. This is not different. This is entirely different from the person who, after he gets drunk and reaches what this trial court found was a state of oblivion, forgets that he was going to call his wife for a ride, or forgets that he had a designated driver.
Yeah, but we don't know in this case whether he did or didn't have someone coming to get him or not and forgotten. I mean, there is no record here to support what you're saying.
And there was no objection to those findings of fact and the people's argument that those were reasonable findings of fact. That was the people's argument from the opening statement. This was not, contrary to what defendant argues, a last-ditch attempt to save this case. The people said in their opening, at page 13, the defendant drank in his friend's home knowing he would be taking a long ride home, and that was his depraved indifference seeking.
So anyone who drinks knowing he's going to drive can be found guilty of depraved indifference if someone is killed or injured?
Anyone who drinks to such an extreme.
Anyone gets very drunk knowing he's going to drive?
Exactly.
I mean, that's unfortunately a lot of people, isn't it?
Yes, it's very unfortunate.
I mean, no one is suggesting that this conduct wasn't criminal. No one suggesting it wasn't a felony. But this is, you're saying that this, if someone had died, this would be murder. Are really
Yes.
all these irresponsible people potential murderers?
Judge, they're not just irresponsible.
They're very
No one
irresponsible.
can claim.
Say they're
that this-
reckless. Say they're reckless.
But they are more than reckless, Judge. No one can claim in this year, in this atmosphere, that they don't know the dangers of drunk driving.
Where do you
And
draw the
I
line?
certainly am.
Judge Piggott, yeah.
Where do you, I want to go back to my first question. Where do you draw the line? Do you say this person, it's the first, he just turned 21 and he's out. So in his case, it might be .11. This alcoholic who's been around the block many, many times, he gets depraved when it's .21. This woman who has never drunk before but now is at a wedding, for her it's .07. I mean, how do we draw that line where all of a sudden it becomes depraved?
You draw that line on a case-by-case basis when a trier of fact looks at each individual defendant and that defendant's conduct and that defendant's intentions and the circumstances of his driving, and the circumstances of his drinking, rather, and each fact finder makes an individual
So that the
decision.
public knows when we make this rule, is that what we're going to say? We've got to come up with a rule here that says this is depraved indifference.
Well, Judge, I don't think that you can come up with a rule if you're talking about a number like the drunk driving statutes provide. We're talking about a defendant who knew he was going to. These are the fact findings. If the court disagrees that there's a basis for them, it's
Well,
a
what I think
position
of,
that's not.
we all can
Sure,
come up with
but-
these ideas, but I don't know why I always come up with football analogies, but you put about 80,000 people in a football stadium, and half of them are tailgating most of the morning until the game, and then after the game, if you ask some of them, they don't know the score. Are they all potential depraved indifference defendants?
I guess they are, Your Honor, depending on how much they drink and how the circumstances.
Okay,
of the-
okay, Kathy. Well, you'll talk a little bit more about that
Thank you.
on rebuttal. Good.
Good afternoon, Your Honors. My name is Marian Karras. I'm here representing the defendant, Alberio Valencia.
What troubles me in this case is the 4 miles that he drove. During that distance, no one flashed their lights at him?
They did.
He wasn't aware? I mean, it does show that he was completely
Oblivious.
oblivious. And
Absolutely.
shouldn't that be a higher level of responsibility?
He is responsible under the law for what the legislature has made him responsible for under the law. And if we want to change that, we certainly can through the legislature. But right now, the legislature has dealt with the idea of drunk driving as it affects assault and murder, and we have statutes on the books that deal with this. By trying to...
Well, how is he less responsible than the defendants in Kibbe?
The defendants in Kibbe had a
They
specific
didn't have
mental
specific,
intent.
they didn't have specific awareness that he was going to freeze to death.
Not specific awareness, but specific intent. They had criminal intent. They had criminal intent at the same time that they were committing a criminal act. Here, my client did
So
not.
when they abandoned him on the side of the road, they didn't care what was going to happen to him.
They were committing a crime against him. They intended that crime, I believe, to be robbery. But they had a specific intent to commit a crime, and they did, in fact, commit a crime. Then, yes, they are responsible for the result of that criminal intent converging with the criminal act.
Is the robbery really necessary? And suppose they had not robbed him, they just left him freezing by the side of the road to see whether he could survive or not. That would still be depraved indifference murder, wouldn't it?
Yes, I believe so, but I think that's still criminal conduct. I think that, taking somebody and taking
Well, of course,
their
but
clothes off.
what your guy did was criminal conduct, too. I mean, you're arguing for a D felony.
I'm not disputing that there was the actus reus here. I'm disputing that the actus reus and the mens rea coincided. I believe they did not
In time,
converge.
you mean?
Yes, in time. They were
What
two
point do they have to coincide? If they don't coincide when he's drinking and when he's driving, do they coincide when he gets behind the wheel? Or do they coincide 4 miles later when there's the accident? At what point does it have to coincide, the actus reus and the mens rea?
I'm going to submit that it has to coincide at the time of the criminal conduct, and drinking in a friend's house is not criminal conduct.
Well,
He was drinking while he was driving.
Oh, I don't believe that there's
They
evidence
found
of
open
that.
containers in the car, and he was drinking a bottle of whiskey while he was driving the 4 miles down the road. Would that change the result?
This is a hypothetical, because that
No, I'm asking a
yes,
different
a
fact pattern.
hypothetical. That very well could. I don't know, but that's not this case.
Why could it explain why you think it could?
If he were in the car sober, completely sober, and at that moment made a decision that perhaps he was going to take a drink and then perhaps he was going to drink while driving and drink himself into a state of oblivion while driving the car, we might have a completely different case.
If he intentionally drank himself into oblivion, if you could prove, which obviously is not this case, that his state of mind was, gee, it'd be fun to drive home the wrong, to get so drunk that I can nerve myself up to drive home the wrong way and see if I make it. If those were the facts, no matter when he made that decision, that's a lot closer to depraved indifference, isn't it?
A lot closer being the operative phrase, and luckily for me, that's not my case, thank goodness.
And I guess to me, I don't quite see why the decision to drink in the car, that a decision to drink at home and get into the car should be different.
Because at the time that he made the decision to drink, he wasn't doing anything illegal, and it all could have turned out all right. Interestingly, and I think...
He was intending to do something illegal. He was intending to drive while drunk.
Well, we don't know that.
Well, let's assume that. I mean, obviously, the whole case collapses if he thought he had a ride home and found out at the last minute he didn't.
Right.
But assume that he knew he was going to drive home while he's drinking.
And then I'm going to cite for you, Your Honor, the people's witness at trial, Dr. William Clausen, who says that alcohol begins to get into the system in approximately 15 minutes. The witness testified that alcohol could cause a person to lack the ability to interpret the appropriateness of saying or doing certain things. So it's a slippery slope.
You need an expert to tell you this?
Right.
Yeah.
But they thankfully put
So
it...
go back to when you have to have the mens rea. Is it the actual moment where you hit somebody or hurt somebody? When is it in this continuum that we're talking about, from drinking at the house, then let's say in the hypothetical that Judge Graffio gave you, that drinking in the car, what's going through your mind as you're drinking? Let's say you're drinking in the car. You were drinking in the house, you got into the car, you started drinking, and then all of a sudden, within, let's say, a minute of what happened, you say, man, I am really out of it. I really better focus because I don't want to hurt anybody. Well, not depraved indifference, or is it?
You see, and...
What's the timeline? Does it have to be at the moment when it happens? That's not a rhetorical question.
I
right?
understand. I'm sorry. I think that there has to be the mens rea at the time you are committing a crime. Maybe it doesn't even have to be the crime of assault, but it has to be a crime. And we're doing this and we're having this discussion about this continuum because we're trying to fit a square peg into a round hole. Because really, the depraved indifference statute that we have in front of us isn't meant for this. And if we want to change the law, we have to do it through the legislature. But you can see that we're having trouble with this.
But how does this kind of situation with a drunk driver, where does the depraved indifference statute fit into a circumstances like this? When is it the case? Clearly, well, you tell me, when is it? When do they intersect that statute with drunken driving, whether you did it in the house and then got into the car, or you did it while you were in the car, or whatever?
Respectfully, my position is that it doesn't.
That it doesn't at all?
Right. That depraved indifference, homicide, is something very, very different. That depraved indifference is wickedness, evil, inhumanity. That's...
Can I give you another possibility? Let's assume you've got someone who has been stopped and arrested and convicted of driving while intoxicated several times, and has his license revoked, and he has no license, and he's clearly an alcoholic, and he nevertheless gets in his car, goes out to a place, gets drunk, and then runs over a pedestrian. I mean, couldn't that rise to the level of depraved indifference? At some point, you got to get it, don't you think?
At some point, the laws have to take into account those kinds of circumstances. I don't know that as the law stands now, depraved indifference assault takes into account even that.
You mean as long as you're totally loopy in Judge Piggott's hypothetical, as long as you're out of it, even in that situation, it's would not be depraved indifference?
Again, even in that situation, it would not be okay.
No,
yes,
I'm not.
right,
I understand.
Right, but it would not be.
If you're out of it at that point, you don't have the mens rea
not depraved
at the
indifference
time of
the way
the
that we're defining it now under
Okay.
the law.
That's your round hole square peg.
Exactly. Thank you.
Okay. Thank you, Kathy.
Thank you.
Counsel?
What about the question of intoxication bearing on the mens rea? The politician somewhat skirted it, even though the dissent dealt with it.
Yes, the mens rea existed when the defendant was sober. And the appellate division never used the phrase actus reus, but they seem to be saying that the mens rea and the actus reus did not exist simultaneously, and therefore the defendant's conduct couldn't support a conviction
As I
for
read
a
what
depraved
the
indifference crime.
was it the county court judge who is the county or Supreme Court, the trial judge, seemed to be saying that that intoxication could not be a defense in a depraved indifference case. Do you embrace that argument?
That was never the people's argument, Your Honor. We made it clear in the county court. We made it clear in the appellate division. It's the people's position, and it was the county court's position, and it is the case, that the actus reus encompasses the drinking. The drinking was the risk-creating conduct that is an element in first-degree assault. It is part of a continuum of a crime. The crime wasn't simply the impact of the cars exclusively. It was a continuum of conduct. And
is it essential to your case that at the time when he was drinking, which is the conduct you complain of, the time when he had either the first drink or the fifth or the 10th or the 15th, that he had to actually know, he had to actually perceive a very high risk that he would cause injury or death?
yes, and it is our position that everyone understands that risk. When they are
Everyone
driving-
should. Isn't it a sad fact that there are a lot of people out there who don't, who always think they're going to be fine? All those other guys are going to have trouble, but I'm going to get home fine. Isn't that the way human beings think?
I think that they understand that there's a risk, and they don't care. They may think the way children do to some extent.
Well, but there's a risk to everything, Counselor. I think the judge is asking you, in your particular case, you know there's some risk, but you believe, you obviously aren't saying, gee, I'm going to drink, and I know I'm not going to get home, but I'm going to keep drinking. I don't think that's the way anyone in the real world thinks about it. For ourselves, maybe we can tolerate more than the next guy. Wouldn't you think that's the knowing human, reactions to
That
things?
what people think is, when they engage in this kind of conduct, that,
go ahead.
that the risk exists.
Yeah, but people, we all know there's a risk when we cross the street after this, these arguments. We know there's a risk. So isn't it the level of that one knows?
Of course it's the level.
I think I'm going to get across the street, although I know that there's a risk,
But you wouldn't try to cross the thruway, because you know that risk is so much more
Well, I
magnified.
might if I didn't see the cars coming, and I see them, they say, well, I can get across before it comes. Maybe you don't quite realize the real risk.
Aren't you in danger of substituting the act of excess drinking for the mens rea that's really involved here, and making the drinking itself a mens rea in
No,
and
Your
of
Honor,
itself?
that was never the people's position. This case depends on the defendant's intending to drive. Every aspect of this case depends.
Well, as Judge Smith pointed out, suppose he thought he had a ride home and he didn't find out until the last minute. By that time, he was absolutely intoxicated. Would that still be depraved indifference?
No.
According to your formula?
No. If the defendant had planned to take a cab home and became so drunk that he forgot that was his plan, then he would not have been drinking with the intent to drive.
Yeah, but you're inferring that wasn't the case. You
Yes, Judge.
admitted that you don't know.
This depends entirely on the county court's finding of fact that the defendant intended to drive home. And any complaint about the insufficiency of that evidence is unpreserved for review.
Okay, counsel. Thank you. Thank you both.